Welcome back to this third part of contract and offer, as we continue with the further situations which are distinct from an offer, and we will also consider how an offer comes to an end in this segment. Well, following on from our last discussion, advertising is also generally not considered an offer. Rather, it is merely inviting offers. Now, the general rule is that advertisement of goods for sale is not to be considered an offer. That's the simple rule. The authority for that, of course, is in Partridge and Crittenden. Again, similar to the display cases, this is another criminal case deciding this particular contract principle. Now, in Partridge, the appellant was charged under legislation for the protection of wild birds with unlawfully offering for sale a wild bird. He had placed an advertisement in a magazine, and the advertisement said, "Bramblefinch cocks and hens, 25 shillings each." The divisional court said that the appellant was not liable for the statutory offence as he had not offered the birds for sale. The advertisement, the court said, was an invitation to treat. The idea is that further bargaining would have been necessary to conclude any agreement to sell the birds. Advertisements of rewards, again, for information or advertisement for reward for return of lost property, will also generally be an invitation to treat. Because in those situations, what the court is saying is that the person advertising is simply puffing. And in the famous case of Carlisle and Carbolic Smokeball Company in 1893, a case I would urge you to read, the Carbolic Smokeball Company placed an advertisement in the newspaper offering a reward of £100 to anyone who bought one of its smoke balls and used it in the prescribed manner and yet caused influenza, or rather caught influenza. Now let's pause for a moment. The idea was this. It was some sort of medicinal purpose this smoke ball was supposed to be used for. So the idea was that if you use the smoke ball, you wouldn't get the flu. Now if you imagine £100 in 1893, that was an awful lot of money. So to show its sincerity in the matter, the Smokeball Company deposited £1,000 with its bank. Again, in 1893, not a small amount of money. Relying on the advertisement, Mrs. Carlisle bought a smoke ball and used it as directed, but she still caught influenza. So she sued, successfully so, for the £100 reward money, and the Smokeball Company appealed against the decision. Now, the Smokeball Company advanced several arguments to defeat Mrs. Carlisle's claim for the reward. They said that the advertisement was too vague and that they did not intend to be bound by it. So basically they were saying they were going along the lines of merely puffing. Now these arguments were of course rejected by the Court of Appeal, which held that both the meaning and the effect of the advertisement was very clear. They said it was immaterial that Mrs. Carlisle did not notify the company of her acceptance before using the smoke ball and catching influenza. The point is that where an offer takes the form of payment or reward in exchange for a particular act or acts, this is called a unilateral offer, and there is no need for the offeree to notify the offeror of his acceptance. Now, previously, we would have considered bilateral contracts where you'd have two parties, but here, in a unilateral contract, you don't need the offeree to notify the offeror of acceptance. Why? Because that type of offer is accepted by performance of the act or performance of the condition. So in Carlisle, the plaintiff was entitled to the reward because the advertisement of the reward was an offer, and as no further bargaining or negotiation was intended by the offeror, the court considered it as such being an offer. So whilst the general rule is that an advertisement is an invitation to treat, if it is couched in terms which clearly shows that the party advertising intended to be bound by what he said, as in the case of Carlisle and the Carbolic Smokeball Company, then in law it will amount to an offer with legally binding effect. Let us now consider tenders and the effect of tenders. Tenders, again, as a general rule, will amount to an invitation to treat. But this is law, which means, of course, that there will, of course, be exceptions. Now, it was held in the case of Spencer and Harding in 1870 that a statement that goods are to be sold by tender is not normally an offer, and so no obligation is created to sell to the person making the highest tender. Equally, an invitation for tenders for the supply of goods or services is not generally an offer, but an invitation for offers to be submitted, which can then be accepted or rejected as the case may be. Now, in some circumstances, however, an invitation to tender may be held to be an offer. In the case of Blackpool and Fylde Era Club and Blackpool Borough Council in 1990, the council owned and managed an airport. It raised money by granting a concession to an operator to run pleasure flights from the airport. Now, shortly before the concession was about to expire in 1983, the council invited tenders for the right to run the concession. Invitations to bid were sent out to the plaintiff and 6 other interested parties. The terms of the bids submissions were that they were to be submitted in an envelope which was provided and should have no mark on it whatsoever which could identify the sender. In addition, the tender had to be submitted no later than 12 noon on the 17th of March 1983. Now, the plaintiff's tender was put in the town hall letterbox at 11 a.m. on the 17th of March. However, although the box should have been cleared at noon, this never happened. The plaintiff's tender was then marked down as being submitted late, and it was not considered. The plaintiff sued, and they sued the council for breach of contract on the basis that it had warranted that had a tender been submitted by the deadline, it would be considered, and that the council had acted in breach of that warranty. The court held on appeal that in certain circumstances, an invitation to tender could give rise to binding obligations. This was just such a case, as the tenders had been sought from a number of parties, all of them known to the council, and the council had also imposed strict rules of compliance on them. It meant that there was an implication that a person submitting a tender in compliance with the council's rules had the right to have their tender opened and considered along with the others. So let's pause there for a minute. This is why at times when you look in the newspapers, you will see a tender being invited, or rather invitations for tenders, and you will see somewhere in there it will generally say, we are obliged to accept the highest bid, the lowest bid, or no bid at all. It is simply because if it is couched in terms that it will be considered, then it must be so considered. Lastly, if a person is simply stating a price, then that will not be sufficient to amount to an offer. So for example, if you ask me, how much does my pen cost? And I say to you, £1,000, because maybe I just happen to use very expensive pens. That does not mean that my telling you the price of my pen meant I wanted to sell my pen to you. This is exactly what the court had to deal with in the 1893 case of Harvey and Facey. This was a Privy Council case from Jamaica. Now, based on some prior negotiations, Mr. Facey, who was traveling on a train, had a telegram sent to him. The telegram was sent by the appellants and it said, "Will you sell us Bumper Hall pen? Telegraph us lowest cash price." Mr. Facey replied, he didn't have anything to lose. He replied on the same day and he said, "Lowest price for Bumper Hall pen, £900. The appellants then replied in the following words, saying, "We agree to buy Bumper Hall pen for the sum of £900 asked by you. Please send us your title deeds in order that we may get early possession." The defendant, of course, refused, and the court said that merely saying what the price was did not mean that the defendant was offering it for sale. Overall, therefore, it is important that an invitation to treat is distinguished from an offer, as an offer will give rise to obligations, but an invitation to treat will not. Let's examine two areas which frequently offer the basis for contract law questions: a vending machine and buying from a website. If we start first with vending machines, well, for vending machines, let's say you put your money in the machine hoping to buy a chocolate bar. Is this an offer or is it an invitation to treat? Well, there is no case on the point, but we could get guidance from Lord Denning's statement in the 1971 case of Thornton and Shoe Lane parking, which we'll discuss later on in another lecture to do with terms and exclusion clauses. The same issues were raised in the context of a car park. Lord Denning explained the whole transaction by saying, the customer pays his money and gets a ticket. He cannot refuse it. He was committed at the very moment when he put his money into the machine. Now, it can be translated into offer and acceptance in this way. The offer is made when the proprietor of the machine holds it out as being ready to receive the money. The acceptance takes place when the customer puts his money into the slot. Now let's pause for a moment. That case had to do with, of course, a car park and putting monies in to get a ticket from the car park machine. So by analogy, it would appear that an automatic machine amounts to an offer, presumably as long as there's an item in the machine to get. And that is how I would suggest you explain it. Now, in respect of websites and buying goods on the internet, given its shopping context, there seems to be a strong argument that it should fall in a similar category as the Pharmaceutical Society and Boots case, or even the Fisher and Bell case, making it an invitation to treat, albeit being on the internet. However, there may be an equally strong argument that if it contained sufficient intention to be bound, as in the Carlisle case, it may be an offer. What is important is to see how the website is presented. Now, there have been some recent situations where retailers have made errors with their offers on their websites. So, for example, Argos Stores, which is a sort of department store in England, inadvertently offered £300 television sets for £3 on its website. Also, Kodak, the camera people, advertised the camera for £100 rather than its retail value of £329. And Amazon as well, one of the biggest retailers, advertised computer equipment for £7.32 instead of £279. What then is the consumer who thinks he's getting a bargain to do? Well, the problem in some of these cases is that sometimes there is an automatic reply to the consumer advising him that his order has been received. However, the overwhelming argument seems to suggest that these types of communication, meaning internet shopping sites, are no more than an invitation to treat based on the Boots and the Fisher cases. And even if, by some stretch of the imagination, it amounted to an offer, then the principle of mistake, which we'll of course explore in a later lecture, would possibly apply here. And the support for that lies in the 1939 case of Hartog and Collin and Shields, where it was held that no contract arises where one party makes an offer to another party and is aware that the other party is acting under a fundamental mistake as to the terms of the offer. It means, therefore, that if we pause for a moment and consider this, if in the Argos case we see a £300 television being advertised for £3, it is clear, or appears to be clear, that there is a mistake on Argos's part. And so it may mean that mistake may be used to vitiate such a contract. Now, there have been some European directives regulating various aspects of the law relating to electronic contracting, but none seem to go so far as defining the status of a website as either an invitation to treat or an offer. At best, what we have is Regulation 12 of the Electronic Commerce EC Directive, Regulations 2002, saying that an order may be, but need not be, a contractual offer. That seems to imply that websites would normally constitute invitations to treat. Right, now let's examine what happens once an offer is established. Well, it must have been communicated to the offeree, as there can be no acceptance without knowledge of the offer, and the supporting case for that is that R.V. Clark gives you the basis for that proposition. Finally, how does the offer come to an end? Well, after this short break, we will conclude this session on offer by reviewing how it comes to an end and what happens when an offer then moves on to acceptance.